Hello everyone, this is Urvashi Chauhan. Welcome back to another episode of Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. Starting with the major news which came from the Union Cabinet, where it approved the Women Reservation Bill. On the inaugural day of the special session of the Parliament, the Union Cabinet has reportedly approved the tabling of the bill. Today, on the second day of the special session of the Parliament, Union Law Minister Arjun Ram Meghwal introduced the bill in the Lok Sabha. This bill, which has a long history of being introduced in the Parliament and getting lapsed, seeks to reserve 1/3, that is 33% of the total number of seats in state legislative assemblies and Parliament for women. The bill proposes sub-reservation for SCs, STs and Anglo-Indians within its 33% quota. According to the bill, the reservation of seats for women shall cease to exist 15 years after the commencement of the Amendment Act. If I tell you its brief background, in 2010, the Rajya Sabha passed the Constitution 108th Amendment Bill 2008, also referred to as the Women's Reservation Bill. Although the constitutional amendment was passed by the Rajya Sabha in 2010, it lapsed after the dissolution of the Lok Sabha and was not placed before the lower house of the Parliament again. As the bills introduced or passed in Rajya Sabha do not lapse, hence the Women's Reservation Bill was still very much active. Also, for your information, let me tell you that a plea has been pending before the Supreme Court filed in 2021 by the National Federation of Indian Women seeking the reintroduction of the Women's Reservation Bill in the Lok Sabha. Around a month ago, the Supreme Court had questioned the central government for not making its stand clear on the issue of women reservation. The Apex Court had questioned as to why the central government had not filed its response to a PIL filed in 2021 seeking reservation for women in legislature. To know more about the bill and other legal aspects, do visit our website at livelaw.in. In another update, today the Andhra Pradesh High Court heard former State Chief Minister and Telugu Desam Party leader N. Chandrababu Naidu's petitions for quashing the FIR as well as cancellation of his judicial remand in connection with the multi-crore corruption Andhra Pradesh Skill Development Program scam case. The matter was heard by a bench of Justice K. Srinivas Reddy. As you know, Naidu was arrested on 9th September by the State Police's Crime Investigation Department, that is the CID, in connection with the scam. Earlier, Anti-Corruption Bureau Court found a prima facie case against the former CM under the charges of cheating, criminal breach of trust, forgery and corruption and sent him to 14 days of judicial custody. Further, his application for house remand was also rejected. Naidu pleaded that the trial court's order sending him to remand was passed without taking into account the fact that the CID had failed to obtain prior approval from the governor in accordance with Section 17A of the Prevention of Corruption Act. According to this provision, no police officer shall conduct any inquiry or investigation into any offence committed by a public servant where such offence relates to any act or decision taken in discharge of his official duty without the previous approval as mentioned in the said provision. Senior advocate Harish Salve, appearing for Naidu, challenged the legality of the FIR in this case. He expressed shock on the fact that the counter was given to them by the state just half an hour before the proceedings started. Describing the present case to be regime revenge, he said that the case was a political battle for the 2024 general elections. Senior advocate Siddharth Luthra, supporting the submissions of Mr. Salve, submitted that all FIRs post-2018, that is after the introduction of Section 17A, needed prior approval of the appropriate authority for investigation. Further, State's Counsel Mithun Rastogi made his submissions. He said that only 10 days had passed since the arrest and investigations had just commenced. Addressing the argument of prior permission for investigation, he said that partaking in a scam by which 370 crores have been deliberated in a calculated manner, this could never be in discharge of public duty. The bench reserved judgment on the petition after a day-long hearing of arguments of the both sides. Stay tuned to know the verdict. The next update for today is regarding the Adani-Hindenburg matter. As you already know, in March this year, the Supreme Court had constituted an expert committee to review the regulatory mechanism in light of the Adani-Hindenburg issue. The committee consisted of 6 members, namely Mr. O.P. Bhatt, Justice J.P. Devdhar, former Bombay High Court judge, Mr. K.V. Kamath, Mr. Nandan Nilekani and Mr. Somsekhar Sundaresan, and was headed by former Supreme Court Judge Justice Abhay Manohar Sapre. If you remember, in May this year, this expert committee had submitted a report before the Supreme Court which ruled out regulatory failure on the part of SEBI in relation to Adani Group companies. Now, in a new development, the petitioner seeking a court-monitored investigation against the Adani Group companies has filed a new affidavit in the Supreme Court, raising apprehensions against this expert committee. The petitioner Anamika Jaiswal has alleged that 3 out of the 6 members of the committee failed to inspire confidence among the people of the country owing to their background and relations with Adani. The 3 members are, first, Mr. O.P. Bhatt. He is the former chairman of SBI, presently working as the chairman of Greenco. The affidavit underlines that since March 2022, Greenco and Adani Group are working in a close partnership to provide energy to Adani Group's facilities in India. And this is a clear conflict of interest. Next, the affidavit also raises apprehensions against Mr. Somsekhar Sundaresan. It asserts that Sundaresan has been a lawyer representing Adani before various forums, including the SEBI board. Finally, the affidavit states that Mr. K.V. Kamath, who was the chairman of ICICI Bank from 1996 to 2009, figured in CBI FIR in the ICICI Bank fraud case. This fraud case related to Chanda Kochar, who served as the managing director and CEO of ICICI Bank from 2009 to 2018. Accordingly, the petitioner has sought for the dissolution of this expert committee and constitution of a new one. Let me tell you, just a week ago, the same petitioner had alleged that SEBI had an apparent conflict of interest in investigating the matter and that it brought in multiple amendments to shield regulatory contraventions and price manipulations by the Adani Group. The Supreme Court has decided to hear in October the appeal pertaining to disqualification of Madhya Pradesh's Home Minister Narottam Mishra, challenging Delhi High Court's decision which set aside Election Commission of India's order disqualifying him. The present issue relates to Madhya Pradesh Assembly elections of 2008. The limit for expenditure for this election was 10 lakh rupees. Dr. Mishra, who contested on the ticket of the BJP, was declared the winning candidate. As required by Section 77 of the Representation of People Act, he had disclosed an expenditure of 2,40,000. But a complaint was made before the Election Commission in 2009, where Rajendra Bharti, the Congress candidate from Datia Assembly constituency, alleged that Dr. Mishra had published certain news advertisements for 4,79,000 rupees and did not disclose the same in his expenditure. Further, in 2017, the EC disqualified Mishra for 3 years. Mishra challenged this order before the MP High Court, but it was transferred to the Delhi High Court by the Apex Court. Further, the division bench of Delhi High Court set aside Election Commission's order disqualifying Mishra. And now the Election Commission has approached the Supreme Court in an appeal against Delhi High Court. The bench comprising Justices Abhay S. Oak and Pankaj Mittal has posted the matter on October 11th. Stay tuned for further updates. Social media addiction among children, also known as social media dependency, has become a growing concern in recent years. As social media platforms are designed to be engaging and addictive, it is difficult for users, including kids, to disengage themselves. It can have negative effects on their mental health, cause sleep deprivation, etc. In this regard, the Karnataka High Court today orally suggested to the union government that it should bring in an age limit for the use of social media. A division bench of Justice G. Narendra and Justice Vijay Kumar A. Patil was hearing an appeal filed by X Corp, formerly known as Twitter, against a single bench decision to dismiss its challenge to the centre's blocking orders. Justice Narendra pointed out that school-going children are these days addicted to social media. There should be an age limit, such as in the excise rules. He said not only on social media, even on the internet, things should be removed as it corrupts the mind. This was while hearing the appeal filed by the X-Corp challenging the single judge bench order which dismissed its petition questioning the blocking orders issued by the Ministry of Electronics and Information Technology under Section 69A of the IT Act. The court had imposed a cost of 50 lakhs on the company. While admitting the appeal, the court had the company deposit an amount of 50% of the cost to show its bona fides. In the appeal, the company has argued that imposition of such exemplary costs is plainly unjust and excessive, and it effectively deters it as well as other intermediaries from challenging blocking orders that violate Section 69A. And that if the single bench decision is upheld, the union government will be emboldened to issue more blocking orders that violate the IT Act, the blocking rules, and the safeguards mandated in the Sharia single case. In another update, the Delhi police today told a Delhi court that the accused in the 2020 Delhi riots larger conspiracy case do not have any right in law to ask for overall status of the investigation or timeline for its completion before proceeding with the arguments on charge. The accused persons, Devangana Kalita, Natasha Narwal, Asif Iqbal Tanha, Miran Haider and Athar Khan moved applications seeking clarity from the Delhi police on the overall status and completion of its investigation in the case. They have prayed that the probe agency be permitted to proceed to the stage of arguments on charge only after filing a report before the court. Special Public Prosecutor Amit Prasad submitted before Additional Sessions Judge Amitabh Rawat of Karkarduma courts that the prayer goes on the assumption that the case diaries are not before the court and that framing of charge attains finality. He further contended that the accused persons slept over their legal rights to challenge the supplementary charge sheets filed by the prosecution because if they felt that they should not have been accepted in law, the applicants should have questioned them. He also submitted that there was no requirement in law for the investigating agency to take court's permission for conducting further investigation in any case. The matter will now be heard on Friday for conclusion of the prosecution's arguments. Stay tuned with us. And now an update from the Allahabad High Court on the incident of police lathi charge on lawyers in the Hapur district. The High Court has expressed dissatisfaction with the preliminary report submitted by the state-constituted Special Investigation Team in sealed cover with respect to investigation in this matter. The report dated 17th September elaborates on the incident which took place between Advocate Priyanka Tyagi and two police officers which led to the chain of events. It states that a car which Ms. Tyagi was driving hit a bike of two police officers. Ms. Tyagi, along with a co-passenger, stepped out of the car and allegedly misbehaved with the police officers. When proceedings were initiated by the police, Ms. Tyagi allegedly did not cooperate. Further, the report states that on 29th August, the lawyers took out a procession from the district court to the Tehsil crossing, where they disrupted the traffic and shouted slogans against the police. The report elaborates how the lawyers allegedly misbehaved with the police officers and thus action was taken against them. At the order of Prabhari Nirakshak, Mr. Sanjay Kumar Pandey, cane was used to charge to control the situation, and that certain police officers also sustained injuries. A bench of Chief Justice Pritinkar Divakar and Justice Mahesh Chandra Tripathi specifically noted that there was no mention of the injuries sustained by the lawyers in the incident. That statements of any aggrieved lawyer did not find any mention in the inquiry report. The court noted that the report did not disclose full facts and was not in consonance with the provisions of CRPC. The court specifically inquired as to why the statements of the two lady lawyers mentioned in the report were not recorded. Thus, the court has directed the state to file a counter affidavit before the next date of listing. And lastly, an interesting news from the Delhi High Court. While quashing an attempt to commit culpable homicide case after settlement between the parties, the Delhi High Court has directed all 24 individuals involved in the matter to do basic cleaning work for 3 days at 4 police stations by dividing themselves in 4 groups. Justice Saurabh Banerjee directed that the said work must be undertaken to the satisfaction of the investigating officer concerned. The complainants told the court that they had voluntarily settled all disputes with the accused persons, did not wish to pursue the criminal proceedings, and had no objection to the quashing of the FIR. A compromise deed was entered into between the accused and the complainants on 2nd October. Thus, the court quashed the FIR registered in July. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share, and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.